Okay, so what changed is federal law. The U.S. Department of Labor changed the level of annual salary that you have to pay an employee in order to make them exempt from overtime and exempt from having to track their daily hours worked. So all of your non-exempt employees, by law, have to record the number of hours they work every day, every week, and you have to pay them time and a half for every hour over 40 in a work week. There is no such thing as comp time. So to avoid that, we oftentimes want to make sure that the person that we put in charge of everything that we expect to be there whenever and put in all the extra hours is exempt. But to be exempt, you now, as of July 1st of this year, have to make $43,888 a year minimum. And that means $844 a week minimum. That does not include the value of any kind of housing or other benefits you provide. That's got to be cash salary. January 1, 25, it goes up to $1,128 a week, or $58,656. Now, that's not a high salary in the world of resident managers, but some properties don't, may not have to pay that much. So just keep in mind that anybody that you have working for you that you want to treat as exempt has to at least make that amount now, and in January, $58,656. And then January of 27, and every 3 years thereafter, they're going to increase it based on compensation data that the U.S. Department of Labor collects. Now, there's something called a highly compensated executive, and that's somebody that doesn't meet all the duties tests to be exempt. And that means that, let me back up now. So, first of all, to be exempt from overtime, you have to meet this salary level. But that's not the only thing. You also have to meet something called the duties test. And to be an exempt executive, which most of our managers we want to fit in that category, have to not only be paid that much, but they also have to supervise 2 or more full-time employees. The majority of their working time has to be non-manual work. And they have to have authority to hire and fire, or effectively recommend hiring and firing. Now, if you're a smaller property and you only have one resident manager and no employees, it doesn't matter what you pay them, they're not going to be exempt under federal law from overtime. So you have to be very careful to make sure not only do they meet the salary test, but they meet the duties test. Likewise, what I'm talking about then is the highly compensated executive allows you to combine duties. Some of the executive functions that I just described, supervise 2 or more full-time employees, authority to hire and fire, majority of the time non-manual work, with other exempt categories such as administrative or professional. Administrative employees do back-of-the-house functions like budgeting, like human resources. So you might be able to meet the exemption test even if you don't have that many employees, if you pay them enough and they perform other functions within the duties test. Now that's just to give you the warning. The change was in the salary level. Those duties tests have always existed. Now, the other thing that happened was we always had this exemption under state law. State law automatically exempted anybody that was guaranteed a salary of $2,000 a month. So we never had to worry about state law for overtime. And in the world of wage and hour law, both laws apply. Federal law and state law apply. And whichever provides a higher benefit, that's what's going to apply. So under state law, we never worried because most people were getting paid at least $2,000 a month, $24,000 a year. That just doubled. The Hawaii State Legislature changed the law effective this year to $4,000 a month. So that's $48,000 a year. So that's even higher than the federal requirement right now. So both categories would apply. Everybody has to make sure that whoever you're treating is exempt, number one, makes at least $48,000 a year. Otherwise, you're not going to meet the duties test no matter what. Okay, so no, that's number one. Hawaii law has a few other exemptions that I think I should mention. See, state law is a little bit easier in meeting the exemption because they only have a salary of $210 a week, as opposed to, what was it, 844. But to be exempt from overtime under state law, if you're not making $4,000 a month, then you have to be paid $210 a week. Primary duty consists of managing the business, authority to hire or terminate employees, and exercise discretionary authority over on a customary and regular basis. Okay, and direct the worker two or more employees. So you still have the two or more employee test for executive. But we have a separate one under state law, a supervisory employee. Now, a supervisory employee, again, only has to be paid $210 a week. Primary duty consists of supervision or direction, but they have to direct the work of at least 5 employees to be exempt from state law. Okay, so $4,000 a month, hire and fire and supervise 2 employees, or supervise 5 employees to be exempt from state law. The reason that matters is if you make a mistake under federal law and you're not paying overtime to somebody, you not only have to pay that person back pay for up to 3 years under federal law of what you should have paid them for the overtime hours, but you have to pay an equal amount as liquidated damages. And then the federal government will assess civil monetary penalties for not keeping track accurately of their daily and weekly hours worked and following the regulations on what you're required to do. So it can get very expensive if you're going back 3 years and calculating how many hours a week your manager was working and not getting paid for. The problem with state law is, under state law, you can go back 6 years. So you want to make sure you comply with both laws to avoid having the liability go back all those years. We're going to have time at the end to ask questions, so I'm going to have to race through this. There's something else that got passed this year called the Pregnant Workers Fairness Act, and final regulations just got passed in June. Okay, now this requires you to make reasonable accommodations for known limitations caused by pregnancy, childbirth, or related medical conditions. Hawaii law is going to be amended soon to conform with this federal law, and known limitations is different than what our state law has always said. We were always required to accommodate disability, a person that's disabled due to childbirth, pregnancy, or related medical conditions. Now we have to accommodate known limitations. They don't have to rise to the level of a disability. So a known limitation gets defined as a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical condition. No level of severity is required, and versus federal and state disability law, which requires a substantial limitation. And pregnancy and childbirth include current or past pregnancy, potential or intended pregnancy, infertility or fertility treatments, or use of contraceptions, labor and childbirth. These are all conditions that are protected by the federal and state law. Oops. And these are some of the other medical conditions: miscarriage, stillbirth, abortions, all kinds of medical conditions related to childbirth or related medical conditions. The employee, I'm sorry, I went backwards. Okay, so how do you know about a pregnant employee's limitations? Well, they can tell you, or somebody in their family can tell you, or their healthcare provider can tell you. There doesn't have to be any kind of specific communication in writing or any kind of form that's used. Verbal communication is enough. And who do they have to communicate to? Anybody with supervisory authority over the employee. In that case, it is triggered that you must take those accommodations to make sure that employee can continue to work who has any kind of known limitation related to those kind of conditions. The kinds of accommodations that are discussed in the rules: more frequent breaks than normally provided, sitting versus standing, schedule changes to part-time work, paid or unpaid leave, telework as an option, parking assignment to make it easier for a woman with a limitation due to pregnancy or childbirth to get into the work situation. Making the workplace accessible to somebody who has limitations due to their pregnancy or childbirth or related conditions. Job restructuring, temporarily suspending some of their responsibilities, essential job functions. Acquiring or modifying equipment or uniforms or devices. Adjusting or modifying examinations or policies. So you can see that the law that was just passed, that took effect last year, and through the regulations, make it very clear that your obligation is to make sure that pregnant females work as long as they want to and can, and you're going to have to make more accommodations and more exceptions to your regular work requirements under this law to enable them to do so. So besides the Pregnant Worker Fairness Act, they passed the Pump Act. And the Pump Act requires you to provide break time to pregnant females and women who have given birth, women who have given birth for 1 year after birth to express breast milk at work. And it requires you to provide a private space, not a bathroom, a private space. And it can't be a space always used by somebody else who just vacates it. So you're going to have to think through what kind of space is appropriate for and private enough for a nursing mother to express breast milk under federal and our state law. Now, if you thought that wasn't enough, the EEOC has now issued guidance on harassment. For the first time in 20 years, they've modified the regulations on harassment to include gender identity and expression. So the federal and state laws protect individuals based on their sex, their gender identity, their sexual orientation, and that encompasses a whole bunch of categories of behavior that cannot be used as a way of discriminating against them and cannot be used to harass them. So this guidance makes it clear that, for example, transgendered individuals are protected under these laws. Sexual orientation, gender identity, and transgender is defined as that a person does not need to have to actually undergo any kind of medical procedure to be considered a transgendered man or transgendered woman. Transitioning from one to the other. And if you wondered what the definition of gender identity is, but gender identity is expressing a gender characteristics that are different than the birth gender. So, what kind of things can constitute harassment? Epithets, saying nasty things about somebody's gender identity or orientation. Physical assaults due to sexual outing somebody, disclosing somebody's gender identity that they are not open with. Harassing conduct because the individual does not present in a manner that would typically be associated with that person's gender. Repeated or intentional misgendering, using somebody's what you would think is their gender proper name versus the name they choose to be called by, can constitute harassment. Denial of access to a bathroom of their choice. And anatomy is not relevant to bathroom use, which is complicated because it gets complicated because the courts and agencies have determined that this concept of somebody espousing or adopting a gender identity different than their birth gender entitles them to use a bathroom that conforms with their own personal view of what their gender identity is. It gets complicated when your gender identity is fluid. You may want to use one bathroom one day, one bathroom a different day. Okay? Now, how do you address that in the workplace? Right? You may have women or men in the workplace. Actually, I had a case where men were upset because a transgendered man was using the showers and everything, and they were uncomfortable with it, and we just, you have to allow that. So bathroom use is another thing. And so some businesses, what they'll do is they'll put a lock inside the bathroom. So you have gender neutral bathrooms, and you can just, lock it when you go in. If you want to go in with somebody, your friends or whatever, to go to the bathroom, you can both go in there and lock the door. But that's kind of been the solution to the male-female bathroom issue. Okay, oh, there it is. Restroom. So some of the answers here: provide employees with access to facilities corresponding to their gender identity. Focus on professional appearance as opposed to you can't wear earrings, or your skirt has to be a certain length, whatever. Again, name and pronoun preferences have to be followed. And you must establish some policies on making sure you keep employees' personal information confidential. And this gets complicated because some people, if you're not aware of this law and how it applies, when people apply for work and they put down male on their application form or on some kind of piece of paper when they're signing up for medical insurance, and they're presenting as a female, you're going to go, what? I thought, what? And you may say things that create potential liability. So people have to be sensitized to accepting and addressing this concept in the workplace, and particularly when you're hiring individuals and managing them, to be sure that you're sensitive to these issues, that your managers understand this concept, and they don't cross the line and create liability for you and your associations. Okay, I got one last thing for you. I know you're going to love this one. Last year, I think I told you about this was coming, but the Hawaii Civil Rights Commission, who enforces all of our discrimination laws, including the law on disability, has proposed rules that have not been adopted yet, but they've been vetted by the Attorney General. And they have now been posted as of July 17th to define illegal drug, as excluding medical cannabis. So for the first time in Hawaii, we have a proposed rule that has the effect of a law that is going to require Hawaii employers to accept the medical use of marijuana in the workplace. And what this provision says is you have to reasonably accommodate somebody's medical use of marijuana in how you test and what kind of workplace rules you have. They make it clear that if it's illegal under state law, you don't have to accommodate it. So if somebody is using marijuana but they don't have a license or medical prescription for marijuana, the medical marijuana, then it would be the illegal use of a drug. But as long as they're a card-carrying cannabis user from an authorized prescriber, you're going to have to figure out how you reasonably accommodate that in the workplace if you're one of the organizations that just a little bit concerned about people coming to work high and working on ladders or using hedge cutters and driving forklifts in some cases. So that's what I had to share with you today, and I hope you have some questions for us on when we get to the question and answer period. Thank you. Oh, I forgot one more slide. I'm sorry. There was one last thing. Last year, the United States Supreme Court made it even harder for employers in the area of accommodating religious beliefs and practices. So it used to be the case that if a person's religious beliefs made it difficult for you to manage scheduling or accommodating their religious beliefs or practices, anything more than a de minimis burden was not required. The United States Supreme Court, without changing that language, made it really clear that what we mean by de minimis is more than what does it say? Unless doing so would result in a substantial increased cost in relation to the conduct of your particular business. So de minimis doesn't mean de minimis. It means a substantial cost to your business. So if somebody says, I have a particular faith and I can't work on Saturdays or Sundays. Well, you have to accommodate that unless you can show that not having them work on a Saturday and Sunday results in a substantial increased cost in relation to the conduct of your business. Or I can't work after 5 p.m. Or I can't work on when the surf is up because I have to go pray to the shark god. So, this is going to create a lot of issues for employers who have traditionally had it much easier in accommodating religious beliefs and practices. Okay, now I'm done. Thank you.